right, so today I'm going to be speaking about physician non-compete agreements. For those of you who don't know me, my name is Sanghavi. I am a clinical assistant professor in the Division of Nephrology, and I currently work at the Puget Sound VA Hospital. All right, so we'll start with what are non-compete agreements. Now, these are restrictive covenants and employment contracts that limit worker mobility based on time, scope, and distance. And in a survey from 2007, about 45% of primary care physicians have signed one. Going back to the history of these non-competes, its first known use was in the 1400s by a master craftsman who'd wanted to prevent his apprentice from setting up shop in the same town for 6 months. He ended up suing his apprentice, but then didn't appear for the hearing. And the judge was noted to have said, "By God, if the plaintiff were here, he would go to prison until he paid a fine to the king." And as you may expect, that restrictive covenants were not contrary to public policy under English common law and American common law as a result. Now, this all changed in 1711 in the court case Mitchell v. Reynolds, which upheld a non-compete if it was limited in time and geography. Now, the rule of reasonableness was then established in the 1831 case of Horner v. Graves. And that was a case of a dentist assistant contract where the contract itself limited employment within 100 miles of his former employer. And this was deemed unreasonable because it essentially prevented the dentist assistant from practicing their trade. And so the current bar for these agreements based on these older cases are that the non-compete must afford a fair protection to the interest of the party in favor of whom it is given, and not so large to interfere with the interest of the public. And this last piece, the interest of the public, is especially important when it comes to physician non-compete agreements. Now, non-compete contracts are really meant to protect trade secrets, and such as ones like a master craftsman may impart to an apprentice. And across industry, you can see that non-competes were more common in, industries in which trade secrets were protectable interest. And so the probability of having a non-compete increased if the protectable interest or the industry you're in was trying to prevent trade secrets from being released. Now you can see that if you work with clients or simply have client info, that did not lead to an increased probability of having a non-compete agreement. Now, finding data more specifically on physician non-compete agreements is extremely challenging. It's not a topic that's often discussed or even researched. And when I typed it into PubMed, you can see that I got 58 results. And PubMed was helpful enough to suggest that perhaps I meant non-complete, in which case there are 198,000 results. Unfortunately, I did not. So I was left with my 58 results. But despite the paucity of information, there is a recognition that access to healthcare is in the public's best interest. And though only 3 states, California, North Dakota, and Oklahoma, have established non-competes to be non-enforceable by legal precedent, many have limitations specifically for physicians. So Massachusetts statutorily prevented physician non-competes in 1977, and really any restrictive covenants for physicians. And that's also the case for Colorado, Delaware, Rhode Island, New Hampshire, and New Mexico. Now others, including Tennessee, Florida, Connecticut, have specific limits on the parameters of their non-competes. So they are enforceable, but they may have geographic limits or time limits that are very specific and only for physicians. Now, many of these states are not bastions of workers' rights, but I think the important thing is that they have realized that physicians are not similar to other employees. And these agreements have real consequences for patients. It prevents physicians from treating underserved populations that may concentrate in urban centers. They disrupt long-term relationships between physicians and patients, leading to worse outcomes. And these agreements, or excuse me, and we've made major steps in reducing fragmented care in many areas of healthcare, but specifically not in this one. And then, of course, the pandemic has brought many issues to the forefront, and this is one of them. Now, this is a statement from the AMA regarding disasters, and they state that it is the ethical obligation for physicians to respond and provide care in the face of a disaster. And you can imagine that employers wouldn't enforce contracts in the setting of, say, a hurricane. But what happens when you have a disaster, such as a pandemic, which stretches over 2 years? COVID-19 has also seen the rise of telemedicine. Many of us have used it over the last couple of years. And non-compete agreements actually impose physical restrictions on the site of care. And for telemedicine services, that patient location is the site of care. So it's difficult to interpret a geographic limit of 30 miles if you're providing telemedicine services throughout the entire state. And further, non-compete agreements can help maintain existing pay gaps for women and physicians who are underrepresented in medicine. Companies can use non-competes as a strategy to lock in employees who lack the resources to contest them. And this is particularly problematic as women faculty are more than 2.5 times more likely than men to perceive gender discrimination in the academic environment. And 59% of Black physicians experience discrimination in their current work setting. So non-competes can prevent people from speaking out or from leaving a discriminatory workplace. Further, in a study of about 1,700 people with non-competes across industries, so not just physicians, men were more likely to negotiate non-compete agreements than women at 13% versus 4.5%. Now, possibly as a result of COVID-19 directly and difficulty interpreting in the setting of telemedicine or issues of health disparities that were magnified by the pandemic, there are currently 30 non-compete bills in state legislatures across the country just in 2022. And Washington updated their non-compete law back in 2020 and stated that the business or organization must demonstrate that the restriction is necessary to protect employers' business or goodwill, that it's no greater than reasonably necessary to secure the employer's business or goodwill. It's reasonable in time and space, and injury to the public does not outweigh the benefits to the employer. They also put in place a few exemptions, specifically for employees earning less than or equal to $100,000, employees who are laid off. The non-compete in Washington state cannot exceed 18 months, and the employer must disclose the terms in writing to the prospective employee by the time the employee accepts the offer of employment. Now, the federal government has also been working to improve workers' rights, and many senators have been working for a long time on this. Back in 2016, the Obama administration issued 2 reports which found the overuse and misuse of non-compete agreements. Senators Warren, Murphy, and Wyden introduced the Workforce Mobility Act in 2018. In 2019, Senator Marco Rubio of Florida introduced the Freedom to Compete Act. It did not pass. And more recently in 2021, the new Workforce Mobility Act was introduced, and Biden issued an executive order. And this is after Biden specifically campaigned on this issue. So these are a few excerpts from the executive order. And I'm not going to read them. I'll give you time to look over them. But overall, they stated that employees should have economic freedom to switch jobs or negotiate a higher wage, and that non-competes limit worker mobility. So what about the other side of the story, the defense for non-compete agreements? So one of the defenses is that non-competes give companies incentive to invest in workers, to develop their skills, make them more productive, and that boost will eventually help the individual worker. The physicians have 4 to 10 years of postgraduate education that they pay for themselves. So this argument doesn't really hold up specifically for physicians. In fact, our on-the-job training is subsidized by the government, not the business itself. Some may say that employees willingly enter into these agreements to provide stability to the healthcare organization and the community. But almost 30% of people don't actually know that they would be required to sign a non-compete until after they accepted a job, which puts them in a very vulnerable position once they have accepted. And this table also shows that very few people negotiate their non-compete, even once they have them. And if they know about it before accepting the job, they're a little more likely to do so, but overall the numbers are low. Another argument is that non-competes are needed to prevent poaching of patients to another practice, which can result in significant loss of revenue to the organization. And if that's the case, they really shouldn't apply to hospitalists, intensivists, ER physicians, radiologists, pathologists, and anesthesiologists who do not have the ability to grow a patient panel and continue seeing them. So what can be done instead? Now, if the goal is to protect legitimate business interest rather than restrict worker freedom, other covenants could be used. If non-disclosure agreements could prevent disclosure of proprietary information, thereby protecting trade secrets. If the goal is to really prevent patients from following the physician, then non-solicitation agreements could prevent this without restricting mobility of the physician. And if the employer truly invested in some sort of training, the employee could reimburse them for these costs. The non-compete could even be optional with a bonus attached to it, being more of a carrot rather than a stick. Now, this topic is getting more traction just in the last year. Media outlets like the Wall Street Journal are reporting on it. Prominent medical journals are examining the issue more closely. Major companies are choosing to eliminate non-competes when they don't align with their mission. And there's been a lot about discussion about non-competes in the setting of telemedicine. So we'll leave quite a bit of time for conclusions. Again, there's not a lot of information that I could find on physician non-competes. But to conclude, non-compete agreements were designed to protect trade secrets, not limit worker mobility. They can worsen existing inequities, specifically for women and physicians who are underrepresented in medicine, and trap them in discriminatory workplaces. They're unethical and pandemic, create legal confusion regarding telemedicine, and there really are covenants better suited to protect business interests without harming both physicians and patients. So that's all I have, and I can leave a few minutes here to take questions.
Hi, Sarah.
Oh, sorry.
Oh, sorry, go ahead.
Do you know the history of why the University of Washington has a non-compete clause?
I do not.
Would you like to know why?
Feel free to share.
So one of the Pellegrini, the head of surgery, who was also the head of UWP, recruited a surgeon to the University of Washington with some great costs to the department. And that person left, and the person left probably because their money that they were going to earn was to pay off of our payment we had with the Medicare fraud. And so because of his position with UWP, he then imposed this non-compete clause that we now have to everyone. And it rests in the UWP sector, and I'm not sure how UWP is totally connected with the University of Washington. In other words, whether or not they fall under the same governance, because there's a lot of issues going on right now within the system that other faculty in different departments, non-medical, do not have non-compete. So we really are sort of not in compliance with the University of Washington as an institution. But I think it's an interesting example of how one person in a powerful position years ago got this non-compete clause in. And my own efforts, I wrote letters to both Tim Dellett and to Paul Ramsey. And I suggested that if they really wanted to give us something rather than applause for all our hard work during the pandemic, that they should do something substantial, like eliminate the non-compete clause. And so there's some committees that will continue to work to try to get rid of this. But to me, it's devastating that this got through the way it did here.
Thank you for that historical background. And thank you for advocating. I think, that's part of the goal here. I think physicians are great at advocating for patients. Oftentimes we're not great at advocating for ourselves. So that's great. I think there's a couple of questions in the chat, so I'm going to pull those up here. All right, so I want to make sure I don't miss anyone. So Justin asked, what's the status of non-compete at UW? And I think Kim probably already answered that one. I think much of it depends on whether you're talking about UW as the UW physicians group or as UW, as Kim mentioned, as a whole. Christine Lamonte asked, what's the consequence of breaking a non-compete? And I think that's going to depend on the lawyers on both sides and whether they can strike an agreement. There are some situations where you can buy out of your non-compete, and that's been used before. Dr. Simmons mentions that there's a separate non-compete system at Children's. I think Fred Hutch also has a separate non-compete system and their non-compete system is to not have non-competes for any of their faculty. Francis asks, do you have any sense of how common non-competes are in the region or nationally? So I left my talk to just publicly available information. A lot of the specifics on non-competes for various places are not publicly available. However, the Puget Sound Business Journal in 2015 did publish a story specifically about physician non-competes. And in it, they interviewed a representative from the Providence healthcare system. Providence does not have non-competes. Evergreen Hospital System does not have non-competes, at least not ones that are required. Whether you can sign one for a bonus is a separate thing, but they are not required. And then in terms of nationally, again, very protected information. So I wouldn't be able to give you that information unless it's a very big hospital system that crosses state lines. And then Chris Logar mentions that anyone who has questions that they don't want to ask in public about UWP or contracts in general can reach out to her. So thank you for that, Chris. Jordan, it looks like Ian wants to know what the approach is at Children's, if you wouldn't mind speaking up.
Sure. It's been a while since I signed because that was in 1999 and things have probably evolved since then. It was also under our practice plan is CUMG, not UWP. So it's partly related to that strange association between the practice plans, the university and the hospital, and who's really your boss. But the way the system was set up was that I was the non-compete proscribed me from practicing nephrology or pediatrics within a radius of many miles around any Seattle Children's Hospital site of practice, which essentially eliminated the entire Pacific Northwest to practice medicine. And I negotiated that away. I actually said, you can't not let me have a job. And so it was when I ended up signing, my non-compete says I can't practice pediatric nephrology, but I am permitted to practice pediatrics. It's probably changed over the years.
I see. So Jordan, the one you did end up signing said that was still in place for not practicing pediatric nephrology.
Yes, that's correct.
Got it. And do you have a sense of the radius currently for you?
My recollection was that it was on the order of 100-mile radius, or something. It was large. And if you drew all the circles on the map, there's a lot of overlap and very few places I could do anything that weren't like, the Hanford nuclear area. So there was almost no place to go.
Yeah. And again, I'm not a legal scholar or lawyer, but that does seem like it would no longer pass the reasonabable-ness test if you were.
I agree with you. I don't think it ever could have, in fact. But nevertheless, when you're young and coming out of fellowship, you want a job. And so that's why I think this is an important topic for all of us to discuss.
Thank you for sharing. And then it looks like Dr. Logar has her hand up. Please feel free.
Just to let people know, even if things are not enforceable and you sign something and people are like, this is not enforceable, it can cost you a lot of money, like tens of thousands of dollars to get out of unenforceable contracts. I personally spent about $45,000 at one point in time in my career. So don't sign anything that you can't live with, I think is a really, really important message. Even though the laws are changing, if your employer has in-house counsel, it's free for them to make your life miserable, and they will. So don't for a second doubt that even though you have the best colleagues and you're joining like the best practice with your dream job, that anybody's going to advocate for you on the way out, your future employer or your current employer. I think that's really important for fellows. And also, if you sign with an organization that has a large footprint, your state law may not apply. So for example, if you sign with a company that's say based in Nashville that has a legal firm in New York that is representing them, then New York laws may apply. So for example, colleagues in California feel like the law doesn't apply to them because they have great laws in the state of California. But if they're signing with a corporation that's represented by New York, it is possible that New York state laws will apply. At the end of the day, it potentially can cost them a lot of money to prove that New York state laws apply. So I just wanted to share, since many of us have never hired lawyers, that it can be very, very expensive. So, and everything is negotiable, everything. There are partners at polyclinics. Some of them have restrictive covenants, some of them do not. As you mentioned, Swedish or Providence does not utilize any sort of restrictive covenants in the area, but every single thing in your contract is negotiable.
Thank you. Thank you for all that information. And sorry about what you had to go through.
Great lessons. I've learned a ton, and I'm always happy to share. I mean that for everyone who needs contract help or just to be pointed in the direction of a lawyer, please reach out before you sign something you don't understand.
And I'll just turn to what I think is our last question here from Amol, who says, is there any you don't? And I think, well, I can tell you at least from what I looked at, I couldn't find anything in the healthcare sector. There are at least speculative arguments in the literature, in the legal literature regarding innovation. And one of the thoughts is that Silicon Valley kind of developed because people could freely move, have startups, and it became this hub of activity because there were no non-compete agreements in California. Granted, there are multiple other factors, such as just having an attractive place to live for young people, and then two major institutions in close proximity. Nevertheless, that's one argument. In addition, people have tried to look at retention. That data is more mixed, and it doesn't seem to have a clear benefit or cost to the organization, at least for non-physician organizations that I could find. All right, Dr. Young gave us some more information here on the Washington law for non-compete agreements specifically for physicians. And with that, thank you everyone for your participation and for your attention.